What does the law say about filming people out in public? Well, as always, it's not as simple as you might imagine. So let's talk about something called the legitimate expectation of privacy. Now, prior to the European Convention on Human Rights and the Human Rights Act, arguably there was no freestanding right to privacy in this country. There's a very similar debate in the US as well. I mean, they've got their sort of Fourth Amendment. But the argument is, well, that sets out the limits of privacy, like nobody can search your correspondence or search your house without a warrant. But other than that, you don't have any privacy. Now, a similar debate happened here where people are saying, well, it's sort of implicit and this, the Fourth Amendment is just a specific example of a general right. But over here, there wasn't, a freestanding right. You could get one contractually. For instance, your contract of employment might say you're not allowed to discuss what happens at work or use any information you learn at work, the old trade secrets cases. And, that's things like just your customer database. Also, you can have these non-disclosure agreements. They're contractual. But what about generally speaking? Well, like I say, the test now is reasonable expectation of privacy. And perhaps the best way of explaining this is to look at the case that sort of set all this out. That was actually Naomi Campbell. She was photographed by the paparazzi coming out of a drug rehab clinic, and they published those photographs. And she sued, for basically a breach of privacy. And there was a big argument as to whether that was even, something you could sue for. But her argument was this was just such personal information that it's not right that it should be splashed all over the newspapers. The newspaper had two arguments. They said, first of all, tough, you don't have a right to privacy. But they said, even if you do, we have this idea that there's no confidence in iniquity. And one reason for breaching privacy is to correct a misunderstanding or a misstatement. And because Naomi Campbell had made a big thing about how she didn't take drugs, but more importantly, that she was better than other models because they all did take drugs. Part of the argument was, well, her argument, of course, I've got all these fans and followers, and also it's just private. I don't want to be going out there saying, yes, I've got drugs. It's, it was a personal battle. But anyway, that all went all the way to the House of Lords. And she was actually successful. Now, she won about £2,500 in damages, but because the newspaper was so confident in their case, they didn't make a Part 36 offer or anything like that, so they were on the hook for £1 million in costs at the end of that. But there are two competing interests. You've got what we call your Article 8 rights, your right to privacy under the European Convention on Human Rights, but people have their Article 10 rights, their freedom of expression. So obviously journalists say, well, we should be allowed to report on things, and sometimes people try to hide things. And if they can claim privacy, that will defeat, transparency and our role as a, not just a watchdog, but sometimes a bloodhound, as it's sometimes described with investigative journalism. But this applies to anybody. It's not the press don't necessarily have any special rights. But when it comes to testing these interests, the first argument is, did you have a reasonable expectation of privacy? Well, if you're out and about in public, just walking down the street, probably not. I mean, there's CCTV everywhere. Everybody can see you. People film everything these days. If you just happen to be in the background, then maybe you don't. But what if it's something intimate? What if you are just coming out of like the doctors? Or in one particular case, somebody was having a mental breakdown and they attempted to end themselves. And that was all filmed and photographed. And they were successful in a claim saying, look, notwithstanding the fact that was in public, there are some things that, it's just prurience. What is of interest to the public isn't necessarily in the public interest. So they said, well, no, that's just not right, that. Common decency says you don't film somebody and publicise it in distress because, what's the reason to do so? There's no sort of journalistic reason, and there's certainly no sort of, hey, I'm just going to stick it up on YouTube reason. But that is the test, and it doesn't really matter whether it's public or private. I mean, you get these quasi-public-private buildings, like shopping malls. Are they a public place? Well, they're probably owned by a private company. But what about, you're down the DSSS? If somebody starts filming down the DSSS, do you want people knowing that you're signing on? So even though that's a public place, you'd probably have a reasonable expectation of privacy there. Now, the mere fact that you're a celebrity and you've put yourself out there, that doesn't necessarily make a difference. The courts say that it's up to people, it's up to individuals, celebrities or not, how much of their life they make public. But that can weigh into the equation. If you're somebody who absolutely courts publicity all the time, like tipping off the paparazzi when you're coming out of restaurants, then arguably you have basically lowered your reasonable expectation of privacy. But some celebrities are very private and personal. They'll do all their celebrity type stuff, do their press junkets, do their interviews, appear on the red carpet. But other than that, they keep themselves to themselves, and they are allowed to. You also get to things like long lens photography. The fact that you can see somebody from a public place doesn't necessarily mean you have a right to film them. Also, children tend to have greater enhanced rights of privacy, although weirdly they can sort of be waived on behalf by the parents. So if the parents are, if a child is a celebrity, and it's hard to imagine that, this is something that children do of entirely their own volition, they've said similar rules can apply. So if a child is a celebrity and they're out and about, then yeah, people are going to take photographs of them. But again, all the flip side is, when they're at school, when they're doing normal kids things, then arguably, no, you can't film that. So, all these dash cam videos and things like that, chances are, yeah, you are allowed to use them and film them. Now, the mere fact that somebody is, potentially committing an offence isn't necessarily gives you a blanket right to film them, though. The general idea in this country is that people, until they are charged or arrested with an offence, you're not supposed to publicise it. Cliff Richard won quite a lot of money because the police tipped off the press, so it was all filmed when he was being arrested. And that's a similar thing. So the mere fact that, you could argue, well, it's in the public interest to disclose this wrongdoing, it isn't always the case. You do have a very strong defence when it comes to that. And also, prevention of crime, prevention and detection of crime can be a defence to harassment. Because, again, like there's a world of difference between just filming a street scene and people walking by and you chasing somebody down the street and sticking a camera in their face. Interestingly, in France, you actually have a right to your own image. So you're not allowed to film people in the street and identify them. France takes that really seriously. You can't buy an unofficial photograph of the Eiffel Tower at night because although the tower itself is out of copyright, the lighting design is still in copyright. And they do take this seriously. If you look at Google Maps of Paris and places in France, a lot of buildings are pixelated out because they attract sort of IP protection because of their designs, and they're still in copyright. So people can't actually film the buildings commercially, and that includes people like Google. So like I say, it's all very, it's a complex issue, but the basic starting position is, do you have a reasonable expectation of privacy? And then, even if you do, is there a competing interest in terms of it's okay to breach that expectation of privacy because it is in the public interest to do so? So that's it. So there you go. As always, hope you found that vaguely useful, vaguely interesting. I'm at somewhere called Gwenap Pit today, which isn't a mine. It's a sinkhole, as you can probably see, but John Wesley converted it into a little amphitheatre, and he used to preach here. It's a quite nice spot. I don't know if it shows up on camera. I'll shoot some B-roll just to show you around the place. The irony is, it's probably a sinkhole because of the mining. Because the first time I heard of this place, I went, oh, that's unusual calling somewhere a pit, because I just did assume it was a mine. Because most mines down here are called wheel something, because wheel being the Cornish for place of work. But also generally used for mines, so it's like, Wheel Bissau, Wheel Ennis, Wheel Plenty. Wheel Virgin is a place I go to a lot, not quite sure why it's called that. But I only know of actually one mine in Cornwall, and that's Wellington Mine, which didn't actually operate until the 80s, so there you go.